Miss Aallyah Wright of Capital B News. And so we got an opportunity to flip the script on her. She's usually interviewing people, talking about rural issues in the Black Belt, and covering the various states and farmers and what is impacting them, and the news, and how they're moving forward with various issues. And recently, she did a story on the railroad in Sandersville, Georgia, where they're taking a 600-acre legacy farm from a Black family through eminent domain to use for supposedly public use, but the railroad is privately owned. So let's look at the story and that she's covering. And it was very near and dear to us because we do a lot of work in the rural community, in heirs property, and land valuation of heirs property specifically.
So that has been one of the focal points of the case, is that the railroad company, Sandersville Railroad, is saying that because this rail spur will open up a channel of trade, that it then will be used as public use. And so first they went through the Georgia Public Service Commission, which basically stamped the approval and said, yes, this is a public use. But of course, on the opposite end of that are Black and white families in this majority Black county, where, they've had this land in their family for generations, and they're not trying to, give it up to build this rail spur, who they think and say that this will be for only, a handful of companies that will be able to transport their goods. And so after the Georgia Public Service Commission agreed to that, that then went to the Fulton County Superior Court, who also agreed with the railroad. And now it just so happened with the Georgia Court of Appeals, the case went to, they basically approved it as well. So these landowners have been fighting with assistance from the Institute for Justice through the courts to try to get a different opinion. But, they have not received that at all, but they're hoping that they can either ask the Court of Appeals in Georgia to reconsider its decision or take it to the Georgia Supreme Court for review. Yeah, I know it's part of, eminent domain that they have to provide just compensation, but, as you mentioned, and as others have mentioned, it's a question mark around just and what that compensation looks like, and even who's the appraiser, what is the appraisal process. But I think in this case, the families, it's not about, money or the compensation. It's the fact that they want to hold on to their generational wealth, their land. They feel like they shouldn't have to, be forced to give it up because of, this centuries old practice of eminent domain, just because a company says, well, okay, you don't want to sell your land. Now we're going to use this process and force you basically to have to give your land up. So they don't want to give it up at all. But to your point, there have been, experts who want to evaluate that process of just compensation and make sure folks, if they have to give it up and they have to, sell it, that they get what they are due.
So this is particularly interesting to me because it goes right into my theory of heritage value that we have developed for heirs property. So under the Uniform Partition of Heirs Property Act in the state of Georgia, there is a provision that creates sentimental value, and it talks about sentimental value being added. It's actually codified in the partition. So what I am in the sentimental value, I think it's the value that goes unrecognized from a community and an ancestral standpoint. And it's this particular model that I'm talking about here. It operates into the great manifest prejudice test. When a court decides whether dividing the property would cause great manifest prejudice to the co-tenants as a group of sentimental attachment is one factor that is weighed alongside practicability of the division and the aggregate value impact. So the thing that we're talking about here is why this matters for the appraisal practice. And again, the market value alone, the way it's done traditionally, does not capture the full value of heirs property to families. And in this particular case, there's a one-time payment. So after that, then the railroad goes on to build wealth, generational wealth, and then the family is left with nothing, no permanence, no anything. And so what happened? One of the things that the company has offered is to re-engage and renegotiate. What I would like to see happen here is, if they are going to take the property, then it should be done in a fact that gives the the heirs, or the people from the eminent domain in the 19 plus acres that they're taking, the ability to participate. And how they are able to participate, if you're really talking about just compensation, they should be able to participate in the input, throughput, and output. And there's already a model for that. We're not reinventing the wheel here. The Bureau of Land Management uses this model. The Department of Interior uses this model for the same thing for railroads going through reservations. The Forest Service uses this model as well, and it's a typical model. This way, this gives those descendants permanence, and you can use their land contribution is the input. And so this way, they have a perpetual lease, so their families can benefit from the wealth and not the extraction that's going to happen from the one-time lump sum payment. So this is one of the reasons why we've started the 10,000 Appraisers Foundation National Appraisal Policy Resource Center, which will be here in Atlanta. 4 cases just like this, in order to modernize the appraisal process to look at things a little bit differently. We utilized the heritage value concept recently in Cincinnati. It wasn't really an eminent domain case, but it could go to be an eminent domain case for a public stadium. And we use it in that framework in order to look at the 1 mile, 3 mile, 5 mile radius. Well, if you do the 1 mile, 3 mile, 5 mile radius, typically what tends to happen is it would give you a view of what's going on. And we were able to look at the 1 mile radius, where the compound annual growth rate was almost 3 times that of the 3 mile and 5 mile radius, allowing us to reconcile to the highest end of the established value range, and justifiably so. So again, it is time. We need to modernize this process, and just compensation isn't just when it comes to heirs, property, and family legacy. And this would be considered one of those times. So I believe the 3-part participation model, input, throughput, and output, could have a significant impact on this Hansen spur, and would go to just compensation. So these are one of the things that we would like to see, and one of the things that we will be framing and working on, and with policy. And because the railroad has offered to re-engage the community and show them how that they would benefit, I believe this is a workable solution here. If you're going to take it anyway, they might as well be compensated, and be compensated for generations to come, as opposed to stealing their legacy. The other piece to that is, it is part of the 5 peers that we testified in recently. First of all, reconsideration of value, if that's codified, this is another opportunity where that would be an opportunity to appeal and get a reconsideration of value beyond the VA for the general public. But the bigger piece of that is the FAEA, Federal Appraisal Enforcement Authority. They could be the final deciding factor on the valuation process and whether it is accurate. Therefore, having a place to implement the reconsideration of value. So again, this is part of where we started the National Appraisal Policy Resource Center. 4 cases are like this that require thinking and modernization, and not just fitting into a box, and that also go to public trust and just compensation and modernizing the appraisal process, which is what the new presidential executive order called for on March the 16th as a part of the access to mortgage credit section, the appraisal modernization section of the access to mortgage credit. So again, this is pretty awesome that Aallyah is covering the story, and it's something that we now would like to follow a little bit more closely.